I've already highlighted my concern. Well, first of all, let me congratulate Senator Housley. I know this has been a labor of great importance to her, and it's quite an accomplishment to have pulled all of this together. My commendation to Senator Housley for that and for all the others that have been involved in putting this together. I do think overall it's a bill that's worthy of becoming law because it does bring us a lot of advances in protecting the residents, which to me is the ultimate purpose of this bill. I've already highlighted my concern about the ability for facilities, which I think they will all do, to put forced arbitration clauses in their contracts. And the fact is, it leaves no consumer choice in that regard because any consumer that is looking for an assisted living facility for their loved one is first going to be looking for a place that has an open bed and one that they think has a decent quality of care. They're probably not going to read the contract all that carefully. If they do, they're not going to understand what an arbitration provision is. And if they understand it a little bit, they're not going to recognize the significance or importance of that provision. So it really is ultimately up to the legislature to protect the consumers in that regard, because in that kind of a provision, the consumers can't protect themselves. But there is another provision that's missing here also, which was originally part of the discussions, and that is what should have been here, which is a private right of action. The ability of an individual to bring a lawsuit against a facility which they believe has negligently or grossly negligently caused them harm, or even intentionally caused them harm. There's no private right of action allowed in the statute here. I want to signify to the stakeholders that my vote in favor of this bill does not signify my acquiescence to this part of the stakeholder agreement. And I will continue to fight to provide a statutory private right of action in these kinds of situations. What happens now is facilities will be able to completely avoid private accountability. They will be able to avoid going to court and having a jury decide whether or not they were negligent in the care that they gave and thereby causing damages. And they will avoid having a jury determine the amount of damages that were caused. There are limitations on the other safety provisions which are in this bill, essentially the regulatory structure. Now, it's great that we're doing it. There's going to be the ability to pull the license of a facility, which won't happen except in the most egregious of situations, and there will be the ability to fine a facility some amount. And that fine is not going to be anywhere near the level of accountability for most facilities that the potential for a lawsuit and a jury verdict would be. And frankly, the enforcement by the regulatory agency, no matter the terrific intention of the existing commissioner, will be subject to two main things. One is the regulatory resources that the enforcing department has available to it, and the will of the agency head to take aggressive enforcement action or appropriate enforcement action. The resources will be subject to the vagaries of our funding process. And there are many of us who are on the floor here today that when we look at even the budget agreement that was reached today, look through that and see areas where we believe that funding is going to be woefully lacking, where the agencies need more resources to do their jobs. They aren't going to get the resources that they need to do their jobs, to regulate effectively, to investigate complaints. I'm thinking in particular, one concern about the Department of Human Rights, but there are plenty of other agencies that are going to be in exactly the same situation. The Department of Commerce has been seeking staff to improve their regulatory ability as well for a long time. And they're going to be stuck with whatever the funding is through our funding and budgetary process. If they don't have the people, they don't have the resources, they will not be able to investigate the complaints, or not all of the complaints, certainly, let alone make decisions about what appropriate accountability measures, license suspension, fines, et cetera, would be right for the circumstances. The other has to do with the will of the regulating agency. We have a Commissioner of Health today who is very intent on investigating complaints about level of care, about violations of licensing requirements, and I'm certain we'll take appropriate and objective action where necessary to enforce the laws. But there may come a time when we have, and this has happened in other levels of government, there may come a time when we have an agency head that comes directly out of the industry that they are going to be regulating. An agency head who may have run a multi-million-dollar assisted living facility company or nursing home company. And they will come into that regulatory position with a very distinct bias to protect the interests of the nursing home companies, the assisted living facility companies and operators. And I fear that they will back off on regulatory aggressiveness to make sure that the laws and the licensing standards are enforced. Without a private right of action, the health and safety of the residents of the assisted living facilities, where you have, I'm not saying most operations are very good and most staff are very well-meaning, but we did see in the past, one thing that generated this whole effort here today were levels of complaints about services that were provided or levels of care that were or were not provided. There will come a time where we're going to wish that we had the ability to bring private lawsuits against some of these multi-million-dollar companies that answer to the bottom line more than anything else. So, members, this is a significant void in this bill. And while I'm going to vote for the bill, I'm going to continue to find a way, try to find a way, to make sure that all of the consumers, all of the residents of these facilities have the ability to bring lawsuits and are not bound by arbitrary or by forced arbitration provisions to hold those facilities accountable in the absence of the ability, which I think there's no way a regulatory structure is going to be good enough to capture all of the accountability that's necessary. Thank you.